Now, Joel Maketa, one of the two suspects arrested most recently in connection with the Thabo Bester prison escape, has been granted bail. Accused number 12, Moeketsi Ramulula, has abandoned his bid. Slindelo Masikane was in court for us, and she joins us now live from Bloemfontein. Slee, obviously that bail hearing happening a little earlier on this morning, one of them being granted bail. Can you just explain to us why the other accused decided to abandon bail? Is this probably also a way of saying they're guilty?
Probably unlikely. There may be some administrative issues. I was hearing on the court corridors that he did not complete his affidavit, and so he had to abandon his bail application at this stage. We don't know. Perhaps that at a later stage he may want to apply for bail. But interestingly, we saw accused number 11, Joel Maketa, then having his affidavit read into the record, and the state telling the court that they were not going to oppose his bail application. He was then granted 10,000 rand bail with some strict bail conditions. Of course, he's not allowed to contact witnesses. He cannot leave Bloemfontein without informing the investigating officer. And of course, he has to report to the Bloemspruit police station on a Monday between 8 a.m. and 4 p.m. weekly. And he has been warned that he needs to make each and every appearance in connection with this case. We also saw something quite interesting in the middle of that bail application with a representative from the Director of Public Prosecution's office requesting to speak to the state prosecutor during that bail application. So we adjourned for about 5 minutes and then resumed with the magistrate, of course, then granting bail to Joel Maketa. But to unpack the latest developments, of course, we know we have 12 people, including Bester, who have been arrested in connection with his escape last year in May. I am joined by a legal expert from the UJ Law Clinic, that is Mr. Alton Hart. Thank you so much for your time once more. Maybe let's just unpack the fact that Maketa is now the 7th person to be released on bail. Do we make any aspersions or assumptions in terms of this speaking to the strength of the state's case against the accused?
Now, obviously, it somehow, because the state would have averred that they've got a strong case against a specific accused person, and that's why they would oppose bail for that person, because they might fear that he or she might flee from the country or flee or evade the trial. The mere fact that they also not opposing bail doesn't necessarily say that they don't have a strong case, but one can draw that inference. So one needs to look at what is the evidence that's currently before court, and obviously you weigh these two up. And in terms of section 60 subsection 11 A and B, one looks at the interest of justice here and exceptional circumstances, but this is not even where they need to put exceptional circumstances. It's just they need to show that they will meet the requirements in section 60 subsection 4 to 9 of the Criminal Procedure Act. And for me, sometimes the prosecutor will say that the state has got a strong case against the person, and sometimes they might just not mention it. And in this instance, they did not mention it, which opens their door to say that, okay, maybe they also don't have a strong case against this witness, and hence they would not oppose the bail in this instance.
What do you make of the representative? From what I understand, Mr. Hart, is that this official from the DPP's office is one of the lead prosecutors in the state, and we had to adjourn in the middle of that bail application for a conversation that took place between the prosecutor in this case as well as that representative from the DPP's office. Is this normal? I certainly have not seen this happen before.
Now, obviously, it is normal that it can happen that a DPP instruction comes and the prosecutor then is tasked. So the prosecutor is then told by the DPP, maybe the Free State office or maybe the national office, to say, listen, maybe you wanted to oppose bail, but we feel like you should not be opposing bail, or you need to ask the court to impose certain bail conditions on a specific accused person. So it happens. Sometimes it happens before the time, but it can also happen in the middle of a session where you are allowed to ask for an adjournment or indulgence by court, just to take an instruction from whoever is the relevant stakeholder in this matter. So it's not unusual, but obviously people from the outside will look at it and say, but I see that there was something that was said there, and they won't just come into a court setting to come and give an instruction. It must be something important that they picked up, that they felt it was necessary to make it and bring it to the attention of the prosecutor, and he then needs to canvass it with the court if needs be. But or maybe there was something that he was about to concede to, that they told him you cannot concede to 1, 2, 3, and hence he had to now sort of have adjust his address, because after the affidavit was read in, he made an address where he said he doesn't oppose bail. Maybe it was even told to him, say, listen, yeah, don't oppose now, although it's a Schedule 5 offense, don't oppose. So there's a lot of things that can happen, and it's not unusual, but it can happen.
Lastly, then, let's look towards Friday. We are expecting Dr. Nandipa. Her lawyers will be making their arguments in her appeal application. You'd remember that she had her application dismissed, where she was requesting that her arrest and her arrest and deportation from Tanzania to be declared unlawful. What are her prospects of success on Friday?
Now, obviously, when one look at it there, and I alluded to this on an earlier occasion, the magistrate in the court of first instance made a fact finding to say that what they did in Tanzania was unlawful. So that fact finding was made. So I think that she's got a very strong chance of actually getting her arrest and the subsequent detention, arrest in Arusha, and her bringing here be declared unlawful and unconstitutional. I think there's a strong chance because the magistrate made that fact finding. And I think also looking at the Supreme Court of Appeal, those guys are very strict when it comes to applying the law and working within the parameters of the law. So if there is a fact finding and the court of did have a side to the papers and the argument, listen to the people, and they most probably won't necessarily sort of interfere with that fact finding. They will just look at, after that fact finding, was the right interpretation given to statute. And I think she's got a stronger chance than the state in that application that is on appeal on Friday.
Just quickly then, Mr. Hart, with this delay, the processes we're seeing in the magistrate's court, do we need to see a finality in Dr. Nandipa's Makudumana's application before we can take this case to trial?
Now, obviously, if that application is pending, she cannot be asked to plead because she's waiting for an outcome from that case. And the moment she has that outcome, and if that outcome is favorable to her, then the state will have to use other mechanisms to actually get her arrested and bring her before court lawfully so. And we don't know what the appeal court might say. And I just have this wild idea that the court can most probably say that you have to take her back to Arusha and leave her there, and she can then decide where she wants to go. So that is a possibility. So, but for me, I see even if she gets a win, it would be like sort of a short-lived win because they can arrest her because there will be a warrant out for her arrest for this current pending trial in the magistrate's court. So even if they say that her arrest was unlawful in Arusha, I think then they will most probably say, okay, we're going to just arrest you now in South Africa, because I think they will make it very difficult for her now to leave the confines of South Africa because they also took the passport that she had in her possession. So for me, it might be a short-lived win, but I also think Thabo Bester will then go that very same route. If the court finds in favor of Dr. Nandipa, Thabo Bester will go the very same route to say that I was also unlawfully arrested and abducted technically, and brought back to South Africa.
Thank you so much for your time this afternoon. That is legal expert Mr. Alton Hart from the UJ Law Clinic, giving us some analysis in terms of what we can expect to unfold in this particular case. And of course, South Africans watching it quite closely to see just how much the state has on the 12 accused so far. And it will be interesting to see whether we see any more arrests before the 8th of August.
All right, Slindelo Masikane, our senior reporter, live for us there outside the Bloemfontein Magistrates Court. This after another 2 suspects appeared there in connection with Thabo Bester's escape.